The title of today's Brandon's blog is CCAA Protection FAQ, 10 easy things you must know to be financial restructuring savvy. My name is Ira Smith, President of Ira Smith Trustee and Receiver, Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you. I hope you can watch until the end of this video, because I know you will find it informative.
Hi.
Brandon's blog below is an entire primer on CCAA protection. What is the CCAA? That stands for the Companies Creditors Arrangement Act, and it allows insolvent companies owing creditors $5 million or more to seek CCAA bankruptcy protection to help them get a timeout and restructure their business operations, and their finances. Then in the blog, Brandon talks about, is CCAA protection the same as Chapter 11? And the answer is mostly yes. Chapter 11 is the section of the U.S. Bankruptcy Code for corporate financial restructuring, as is CCAA in Canada. Brandon then talks about what is the stay. When you go to court and you make your initial application for CCAA protection, if you're successful, the court will issue an initial order, and that initial order has embodied in it language that says all creditors cannot either begin or continue any enforcement action to try to collect their debts from the company. That is what the stay is. Brandon then discusses the comeback hearing. When the initial order is granted, it is only good for 10 days. Then there has to be a comeback hearing. When the company seeking restructuring files its initial application, it either goes on an emergency basis and hasn't served anyone, or only serves the major stakeholders. It certainly does not serve all the creditors. So what the comeback hearing is for an opportunity for creditors who were not initially served and then learned about the initial order and the stay to come to court, if they choose to do so, to say why they will be prejudiced if the initial order is extended, because CCAA orders can be extended. And as a matter of fact, the court requires the company and its monitor to come back to court on regular time intervals to report on the status of the restructuring, and for the court to determine how much longer in the next phase the court should give the company and its monitor before it has to come back to court and report again. Brandon then discusses what is the monitor, which is the licensed insolvency trustee appointed by the court to assist the company in its restructuring, to be the financial advisor to the company, and to interface with the creditors, to explain the process to them, and to administer the process, including the creditor claims process. Then Brandon talks about the plan of arrangement, or as it is sometimes called, the plan of compromise. And what that is the actual restructuring plan that is put before the creditors to vote on, and if successful at the vote, then filed further with the court in the application to approve the restructuring plan of arrangement. Financial statements of the debtor, Brandon then talks about. When the company makes its initial application, it has to include a copy of all financial statements issued in the 12 months before making that initial application to court. And if none were issued, then it has to supply the most recent set of financial statements for the court to understand the financial position of the company. Brandon then talks about the need for creditor approval of the plan of arrangement. Creditors can be divided up into various classes. Each class of creditors, there has to be a commonality amongst them. Then each class of creditor is entitled to vote on the plan of arrangement. The test is that within each class, in order for the plan of arrangement to have received a favorable voting from the creditors, each class has to vote in a two-pronged test. There has to be a simple majority in number, and 2/3 of the dollar value of the claims voting is the minimum necessary. 2/3 has to vote in favor, at least 2/3, plus the simple majority in number for that class to have voted in favor of the plan of arrangement. When all the classes have voted in favor, then the company makes an application to court for court approval. And to help you understand the best way what factors the court needs to consider when the company makes its initial application, whether or not to grant that initial order, Brandon discusses a recent decision from the Supreme Court of Newfoundland and Labrador when considering a specific company's application for an initial order for CCAA protection over the objections of its main secured lender. So I hope you can read the entire Brandon's blog below, because I know you will get value from it. Again, both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you.